Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw, where we bring you the most important updates and intriguing developments straight from India's courts. So let's see what's making headlines today. Starting with a critical exchange where Senior Advocate Vikas Pahwa has written a letter to Sanjeev Sanyal, who is a member of the Prime Minister's Economic Advisory Council, objecting to Sanyal's public remark that the judiciary is the biggest hurdle to India's aspirations of becoming Viksit Bharat. Sanyal had criticized judicial intervention, court vacations, rituals, and suggesting that the judiciary delays development and needs modernization. In this letter, Pahwa described Sanyal's statement as sweeping and dismissive, warning that it risks undermining public trusts in courts. Pahwa responded that courts do not obstruct progress, but ensure it happens within constitutional values, fairness, and liberty. He pointed out that systemic constraints such as judge shortages, infrastructure deficits, and judicial reforms like reduced holidays and partial working benches as causes of delay, not judicial indifference. He also defended courtroom traditions, saying terms like prayer in legal pleadings and my lord are not colonial hangovers but conventions conveying respect and dignity. Even though this is not the first time these issues have been raised, the tone and the sweeping manner in which it was said, also considering the position occupied by the said person, definitely raises concerns. Next, we take a look at important update from the taxation law sphere as the Supreme Court has struck down a Rajasthan government notification that allowed value-added tax exemption for asbestos products manufactured within Rajasthan while those imported from other states were taxed. A bench led by Justices B.V. Nagratna and K.V. Vishwanathan held this differential tax treatment to be discriminatory, saying states cannot use the weapon of taxation to protect local manufacturers at the expense of interstate trade. The court referred to Article 301, Trade and Commerce Throughout India, and Article 304A, which allows states to impose taxes on imports from other states only on condition that they do not discriminate. The notification failed that test. It emphasized that while states can design fiscal laws, they must ensure equal tax burdens on goods made within the state and those imported. Whether the burden is truly equal is a matter of fact in each case. With this decision, the court reaffirmed India's constitutional commitment to a unified market, ensuring states don't create hidden trade barriers under the guise of taxation. In another important development that might be able to address one of the most widespread complaints with the judiciary, the Supreme Court has stressed the urgent need to revive day-to-day trial practices, particularly in sensitive and high-profile cases. Justices J.B. Pardiwala and K.V. Vishwanathan noted that continuous trial sessions, which were a common practice 3 decades ago, have largely fallen into disuse, leading to unnecessary delays and undermining the timely delivery of justice. The court observed that fragmented hearings spread over months or even years compromise both efficiency and fairness in the judicial process. To address this, it has directed all high courts to constitute committees to devise strategies for reinstating day-to-day trial practices in their respective jurisdictions. While acknowledging challenges such as limited judicial resources and scheduling constraints, the court emphasized that the benefits of continuous trials, ensuring timely justice, reducing backlogs, and preserving the momentum of proceedings far outweigh these difficulties. While acknowledging challenges such as limited judicial resources and scheduling constraints, the court emphasized that the benefits of continuous trials ensuring timely justice, reducing backlogs, and preserving the momentum of proceedings far outweigh these difficulties. The guidelines make a decisive push towards revitalizing the judicial process and ensuring that critical cases are handled promptly and efficiently. This decision, if implemented to the letter, is expected to have a wide-ranging impact on how courts manage sensitive cases, reinforcing the principle that justice delayed is justice denied, and emphasizing the importance of consistent, uninterrupted trials. Next, in a reaffirming ruling for the senior citizens of our country, the Supreme Court has allowed the eviction of children if they fail in their obligations to take care of their parents. The case involved an 80-year-old man and his 78-year-old wife who sought eviction of their eldest son from 2 Mumbai properties he had occupied and had refused them access. The parents filed a complaint on July 12, 2023 under sections 22, 23, 24 of the Maintenance and Welfare of Parents and Senior Citizens Act. The tribunal had directed eviction and a 3,000 rupees per month maintenance, which was upheld by the appellate authority. But the Bombay High Court overturned the eviction, reasoning that the son had become a senior citizen by then and thus could not be evicted. But the Supreme Court disagreed. The bench of Justices Vikram Nath and Sandeep Mehta held that the High Court misapplied the law, that is, the relevant date to determine who is a senior citizen is the date the eviction application is filed, not a later date. Since the son was under 60 when the parents filed, he was not a senior citizen under Section 2, Clause H of the Act 10. The court emphasized that this act is welfare legislation meant to safeguard older persons, and so its provisions must be construed liberally to give effect to that purpose. It reaffirmed that tribunals under the act can order eviction of a child or relative when there's a breach of obligation to maintain their parents. As a result, the Supreme Court allowed the appeal, set aside the High Court decision, and gave the son 2 weeks to provide an undertaking to vacate the premises by November 30th. Or allow the tribunal's eviction order to be enforced. This case is a reminder that owning property does not give children an absolute right to occupy it. If they fail in their duties to care, the law will make sure that elderly parents can protect themselves when children turn neglectful. In another issue that has been dominating headlines in Uttar Pradesh, the Supreme Court has intervened to allow Ramlila celebrations at a Firozabad school ground to continue despite an earlier stay by the Allahabad High Court. The High Court had passed an ex parte order after a PIL alleged that the school playground was being converted to a permanent Ramlila venue with interlocking tiles, swings, and a Sitaram gate restricting student access during the 18-day event. The PIL claimed teaching and play would be disrupted. The Supreme Court, however, stayed the High Court's order, noting the festival has been held at the school for nearly a century now. The bench of Justices Suryakant, Ujjal Bhuyan, and N. Koteshwar Singh allowed this year's celebrations to continue, provided students' classes and playtime are not affected. Going forward, the court directed the district administration to find an alternate venue for the Ramlila, ensuring school grounds remain accessible for students' primary use. Next up, the state of Chhattisgarh has caught the attention of the judiciary for all the wrong reasons. In Chhattisgarh, 400 vehicles purchased for the Dial 112 emergency services have been lying unused for nearly 2 years now, prompting the High Court to take suo motu cognizance of the situation. Reports reveal that these vehicles, which cost around 40 crore rupees, have sat idle with parts deteriorating. The avoidable repair cost per vehicle is estimated at 50,000 rupees, and their effective lifespan has fallen from 10 years to 8 years. Adding to the concern, 325 new vehicles were procured in April 2025, and rather than deploying them, the police headquarters ordered repairs for the older vehicles, leaving the new fleet parked and unused. A division bench comprising Chief Justice Ramesh Sinha and Justice Bibhu Dattaguru criticized the indecision in tendering and agency selection, noting that such delays have caused financial burdens, administrative setbacks, and operational inconvenience for the police. The court has now directed the Director General of Police to file a personal affidavit detailing why the procurement went unused, the reasons behind the administrative delays in tendering, the steps to be taken next to maximize vehicle usage, and measures to prevent such mismanagement in the future. The matter is scheduled for hearing on 8th October, and LiveLaw will continue to track updates as the situation develops. Next, the question of agricultural imports also came up before the Supreme Court today, as it issued a notice to the centre in response to a public interest litigation filed by Kisan Mahapanchayat, a farmers' organization challenging the government's policy of allowing duty-free imports of yellow peas. The petition argues that this policy is detrimental to the Indian farmers, particularly in the context of pulses like urad, tur, or chana, which are being undersold due to influx of cheaper imported yellow peas. Advocate Prashant Bhushan, representing the petitioners, highlighted that the Commission on Agricultural Costs and Prices had recommended a ban on yellow pea imports in March 2025. Citing adverse effects on domestic agriculture. Additionally, the Niti Aayog's September 2025 report emphasized the need to reduce import dependence and increase domestic pulse production to ensure long-term food security. The PIL points out that the yellow peas are being imported at approximately 3,500 rupees per quintal, while the minimum support price, or the MSP, for domestic pulses is around 8,500 per quintal, creating an unsustainable market environment for Indian farmers. The Supreme Court's intervention can be seen as a demonstrative moment regarding the growing concern over agricultural policies that may inadvertently harm domestic producers. As the case progresses, it remains to be seen how the government will address these critical issues affecting the livelihood of millions of farmers. And finally, we take a look at the Goa bench of the Bombay High Court that has ruled on the disclosure of Aadhaar related information to law enforcement agencies. Justice Valmiki held that providing demographic information such as proof of identity, proof of birth, and proof of address to the police does not amount to disclosing personal information under the Aadhaar Act. The case involved Yaniv Benaim, an Israeli national who obtained an Aadhaar card in 2021 without valid documentation, despite having been deported from India in 2011. The court noted that the Aadhaar Act entitles any resident of India to obtain an Aadhaar number after providing demographic information, irrespective of nationality. Benaim was facing multiple criminal charges, including offences under the NDPS Act, the Prevention of Corruption Act, the Foreigners Act, and the Passports Act. The High Court directed the Unique Identification Authority of India to disclose Benaim's demographic information to the Goa police to assist with the investigation. It is a serious reminder of the importance of strict verification procedures and lawful use of information under the Aadhaar framework, which seems to be completely lacking. That's all for today's edition of Courts Today by LiveLaw. Stay tuned with us for more updates from India's courts, where every case has a story and every judgment can shape the country. Follow us on Instagram, YouTube, and www.livelaw.in to never miss a beat in the world of law. I'm Devajit Das. Thank you for watching.